Hello students, welcome to iExamB and embrace the iExamB learning experience. Students, I had started a series with respect to the chapter-wise revision of the various chapters that are there under the Companies Act with respect to the various competitive law exams. With respect to that series, this is the further part wherein I'll be going ahead and discussing the further chapters, the provisions that are therein. Till now, I have come up with around 7 parts. And in case if you have missed to watch any of those parts and you want to watch them, you can go to the description of this particular video wherein you can find the link of the previous videos and you can watch them. At the same time, if you have any questions, queries or doubts which you want to clarify with us, you can connect us through the email ID or the phone number which is displayed on the screen and we will be helping out with your queries. Do remember to subscribe to the channel and press on the bell icon so that you can stay tuned and stay updated. Now moving ahead with our today's discussion, as I already mentioned, we'll be going ahead with our chapter-wise revision of the Companies Act 2013. So in this particular part, we'll be discussing chapter 15 and chapter 16. If we look on to chapter 15, that is basically talking about compromises, arrangements and amalgamations. So before we move ahead with the various procedures, the various provisions that are there with respect to these, first we'll be looking on to each of these terms. Now, if we talk about compromise and arrangement, these two we can simply understand as the legal mechanism. And this legal mechanism is with respect to what? The restructuring of the company, its operations, consolidation of assets and all that can be basically used by the company. So, compromise and arrangements, they are basically referred to as what? The legal mechanism or the process under which the company will be going ahead and restructuring what? Its debts, equity, or it could be both, and that has to be acceptable by the shareholders, the creditors and all. ये जो entire process होगा compromise और arrangement का, this will be involving negotiations. Okay, there will be negotiations that will be taking place and that will obviously be between the company and its stakeholders. Further, वहाँ पे जो है authorities की approval and all भी चाहिए होगा with respect to going ahead with the compromise and arrangement. अब ये जो term compromise है, ये as such defined नहीं है Companies Act के अंदर, बट कॉम्प्रोमाइज को हम सबसे इजी फॉर्म में समझ सकते हैं एज एन अग्रीमेंट और सेटलमेंट यू कैन से विच इज अग्रीड बिटवीन द कंपनी एंड इट्स क्रेडिटर्स, द शेयर होल्डर्स यू कैन से, अदर स्टेक होल्डर्स यू कैन से, with respect to resolving the dispute or differences. So basically for the compromise there is a pre-existence you can say of a dispute with respect to which the compromise will be achieved. So we can say in other words that there can be no compromise and all until and unless there is some dispute that is in existence. Now if we talk about the term arrangement, what does arrangement mean? So arrangement typically हम कह सकते हैं involve करेगा restructuring and all company के affairs को, operations को, ownership structure को through formal plan which will be approved by the creditors, regulatory authorities, shareholders and all. So in that particular way you can say what arrangement is basically, and that can be arrived between the company, its creditors, members, etc. Now if we talk about amalgamation, amalgamation in simple you can understand as the merger or consolidation of two or more companies into a single entity. अब यहाँ पे जब मैंने बोला कि it is the merger of two or more companies into a single entity, तो एक टर्म आ गया merger. अब ये merger क्या है ये भी हमें समझना होगा. So merger को हम कह सकते हैं कि जब two या more companies जो agree करते हैं कि वो अपने operations को combine करेंगे and they will be forming a single entity. They will be coming together and forming a single entity. Then we say that there is a merger of the companies. अगर merger की हम फिर से अगर बात करें, we take say assume two companies are there. So if there is a company A and there is a company B, okay, this is before merger, these companies are there and they are having their own operations, their assets and all. Now after merger, this is after merger, this is before merger. Now after merger, these two companies, they will be combining to form a single company, you can say a larger entity that will be referred to as the merged company. Okay, so this will be the merged company that will be formed, and this particular merged company, the new entity that will be formed, it will be including the operations, the assets of both the company A and B that will be involved over here. So that is what you can understand in simple a merger is. So after merger, the merging companies, they will be ceasing to exist independently and all their assets, जो भी liabilities है, operations है, सारे transfer हो जाएंगे जो ये company form हुई है, the newly formed entity you can say, or in that case there could be the surviving entity, to that it will be transferred. Now if we talk about amalgamation, so it is also similar to merger, but it is we can say is referred to as a specific type of merger, जहाँ पे कि one company जो है absorb करेगी दूसरे को. तो basically amalgamation में जो है एक dominant company होगी, ठीक है, वो dominant company जो है that will be taking over the assets, liabilities etc of the another company. तो जो amalgamating company होगी वो सीज कर जाएगी exist करने, और उसके जो भी assets और liabilities होंगे वो जो है that will be becoming a part of this dominant company, that will be the surviving company. So before amalgamation you can say these two companies are there, A and B, and after amalgamation if this is the bigger company, it will be going ahead and absorbing the smaller company, that is the company B. तो उसके जो भी operations हैं, assets हैं, वो जो है that will be becoming a part of company A, which is the bigger one, and B will be coming to an end, ceasing to exist independently. So that is what amalgamation you can understand. So both merger and amalgamation, they will be involving the combining of companies. जो key distinction होगा that will basically lie in whether the companies basically they merge to form a new entity. If the new entity is formed, we say it is merger, and say if the company is absorbing the another one, then it is the amalgamation. Now with respect to chapter 15, you can see section 230 is there, which is talking about power to compromise or make arrangements with creditors and members. Okay, so basically compromise or arrangement that can be between the company and its creditors or company and its members. With respect to that, application can be sent by the company, the creditors, members, the liquidator. Application किसको जाएगा? Tribunal को जाएगा. So once the tribunal is going ahead and receiving that particular application, it may order the meeting of the creditors, members, etc. Now, the particular applicant will also be going ahead and disclosing certain things to the tribunal by way of an affidavit, जिसमें material facts जो हैं include किए जाएंगे. Then reduction of share capital if it has taken place with respect to compromise and arrangement, that will be included. Any scheme with respect to corporate debt restructuring and all, with respect to that also there has to be an affidavit. Then there will be a notice with respect to the meeting which will be sent to the creditors, the members, debenture holders, all of them at their registered address. That will also be placed at the company's website. अगर listed company है तो SEBI and stock exchanges पे वो place किया जाएगा, newspaper में publish किया जाएगा. So these things have to be done with respect to that. Now persons जिनको भी वो notice send किया जाएगा, they may go ahead and vote in the meeting, and that voting they can do by themselves through proxies, postal ballot, electronic means, and that has to be done within 1 month. अगर कोई objections and all are there with respect to the proposal, that can be raised by the persons who are having not less than 1/10 of the shareholding or outstanding debt amounting to not less than 5% of the total outstanding debt. Report of result of the meeting, that will be stating the number of creditors, members, they were present, who all voted, it was in person, proxy, all those details have to be there, and the report has to be submitted to the tribunal. That has to be done within a fixed time if the tribunal has fixed any time as such, or if not, then in that case within 3 days it has to be basically submitted to the tribunal. Now notice along with all the documents and all that will be sent to all these authorities, and if there is any representation and all, they can go ahead with that. In case there is no representation that is basically made within the time frame of 30 days, then there will be the presumption key. There is no representation with respect to that particular proposal, and order of tribunal that will be filed with the registrar. Now section 232 is talking about merger and amalgamation of companies. So where the companies they apply to the tribunal under section 230, which we saw previously, section 230 for approval of compromise and arrangement, उन्होंने application किया, that is involving merger and amalgamation of companies. तो उस case में जो है, there are certain things which will be taken care of by the tribunal, and with respect to that, there are certain things which are required to be shared with respect to the meeting, like draft of the proposed terms of the scheme, confirmation that the copies of the draft scheme they have been filed with the registrar, report adopted by the directors of the merging company, explaining the effect, etc. of compromise on shareholders and other parties. Copy of the expert with regard to valuation, that has to be there. So all these are required, they are required to be shared and all, and the company will be going ahead and furnishing to the registrar copy of the order within 30 days for registration and all. Then section 233, it is talking about the merger of certain companies, and these certain companies are who? These two or more small companies. It can be holding company and its wholly owned subsidiary, या फिर other classes of companies. ठीक है? And there has to be certain conditions on which the scheme of merger and amalgamation that can be entered between these companies. So if we talk about that, notice will be there with respect to inviting objections, you can say suggestions and all, and that will be given to these parties, registrar, official liquidator, etc. Objections and suggestions which are received, they will have to be considered in the general meeting. Companies, the ones which are involved, they will be filing declaration of solvency also. So all these are required to be done. Transferee company will be going ahead and filing a copy of the approved scheme with the central government, official liquidator, registrar and all. Once that is received, if these parties, the authorities, they have any objections, suggestions, etc., they can go ahead with it. If no, then in that case, central government will be doing what? Will be registering the scheme and issuing the confirmation to the companies. Now, in case if the registrar, official liquidator and all, they have objections and all, they can go ahead communicate that within a certain time period. Again, you can see it is of 30 days. And that has to be done to the central government. Central government, once it receives those objections, suggestions, etc., and it is of the opinion that वो जो scheme and all है वो interest पे नहीं है creditors के, public के and all, then the central government can go ahead and file an application before the tribunal. So once the tribunal receives the application, it may direct the scheme to be considered, and the confirmation order and all has to be communicated to the registrar. Registrar will be registering the scheme and all those will be taking place. So the registration of the scheme, that will be considered to have the effect of dissolution of the transfer company. Okay. Now talking about chapter 16, that is prevention of operation and mismanagement. So there has to be a prevention of operation and mismanagement. Okay. So operation basically कब occur होगा? जब जो rights and interest हैं of minority shareholders, they are basically disregarded or unfairly they are prejudiced by the majority shareholders or the management of the company. That can basically involve anything, actions such as it could be, you can say exclusion from the decision making, या फिर unfair treatment and all, या फिर diversion किया जा सकता है company के funds को for personal gain and all. So ये जो operation होगा with respect to the interest of the minority shareholders or other members of the company, that can lead to a sense of, you can say, injustice and unfairness among those minority shareholders, and at the same time it will be affecting the very performance and reputation of the company also. Now if we talk about the mismanagement, so mismanagement is basically improper या आप कह लो negligent management, जो भी company के affairs and all है उसका negligent या improper management. By whom? By the directors, जो management team है. So उसमें it could be anything, it could involve the actions such as, you can say, it could be the failure to exercise due diligence, या फिर decisions that are not in the best interest of the company and all. So the shareholders and the members, they can basically go ahead and seek remedies for mismanagement through legal action and all before the regulatory authorities and all. So operation जो है involve कर रहा है क्या? Unfair treatment या prejudice होता है against the interest of the minority shareholders. Mismanagement जो relate कर रहा है improper या negligent management practices का, जो कि कंपनी को हार्म कर सकता है, उसके स्टेक होल्डर्स को. एंड बोथ ऑफ दीज ऑपरेशन एंड मिसमैनेजमेंट, दे हैव अ सीरियस consequences for the company's performance, you can say governance, stakeholder relationship and all. So prevention of operation and mismanagement is very important aspect with respect to the companies. Chapter 16 is laying down the various provisions with respect to that. So अगर हम वहां पे बात करें section 241 की, तो that is laying down the provisions with respect to application that can be made to the tribunal for relief in cases of operation, etc. So basically, who all have the right to go ahead and apply? The right to apply is there with respect to a member if in case affairs of the company, they have been or are being conducted in a prejudicial manner. That is prejudicial to who all? You can see public interest, oppressive to him or any member हो सकता है, company का interest जो उसके context में prejudicial है, material change in the management. Central government can also go ahead suo motu and apply with respect to that. If say the business of the company that is not being conducted and managed as it should be, या person जो concerned है in the conduct and management of affairs of the company, they are guilty of fraud, etc. So in that case, central government can also go ahead on a suo motu basis. There are various grounds you can see the section has provided. Business is being conducted in a manner which is with the intent to defraud the creditors, members, etc. So these are all the grounds which are there, which are provided under section 241, that is talking about application to tribunal for relief in cases of operation, etc. Section 244 is talking about what? Right to apply under section 241. So application कर सकते थे, कौन से लोग कर सकते थे, on what all grounds we saw in section 241. ठीक है, अब ये जो right है उन लोगों को to apply, that will be given to them if there are certain requirements they are met, that is provided under section 244. So members having right to apply किनको है? अगर कंपनी के पास share capital है तो if this is the requirement, if it is fulfilled, these members they can go ahead and apply. So if the company is having share capital, वहाँ पे क्या है? Not less than 100 members of the company या not less than 1/10 of the total number of its members, whichever is less, they can go ahead. Any member who is holding not less than 1/10 of the issued share capital of the company, subject to the condition that the applicants has or have paid all the call sums due on their shares. Now, जहाँ पे company is not having share capital, not less than 1/5 of the total number of the members, they can go ahead and make the application. So that is what section 244 is providing. Then section 245, it is talking about the class action. अब ये class action क्या हो गया? In simple, if I say class action जो है एक legal action है that can be brought by a group of people who actually have suffered similar harm or injury, you can say, and so they all have the right that they can go ahead with the class action suit. Okay, so with respect to going ahead with the class action suit, there are certain requirements which have been mentioned under section 245. So the members, the depositors, or it could be any class of them, they may go ahead, and if they feel that the management or conduct of the affairs of the company, they are conducted in a manner which is prejudicial to the interest of all the company members, depositors, then they can file an application before the tribunal on behalf of the members, depositors, etc. for seeking the order. इसके लिए कुछ required number of members and all है, which you can see over here. Company having share capital के लिए कुछ requirements है, and the companies who are not having share capital उसका अपना requirement है. Depositors अगर हैं तो उनका required numbers है, those have to be complied with, and then class action suits they can be taken ahead. So with this we come to an end of our discussion of this particular part. Do remember to subscribe to the channel and press on the bell icon so that you can stay tuned and stay updated and make your preparation 50% faster with us at iExamB.